Okay, so now we will see what are the remedies available if one of the party has breach of the contract. Okay, so there are variety of the option available. Number one, if you look at on the right hand side, look at my pointer. He may continue to fulfill his obligation, but at the same time, he may claim for the damages against the party. Okay, this is one of the option. I give you the same example, like A is having the contract with B. In this similar scenario, B has breached a contract. What are the options available? One of the option is available by A is they can go, A is able to continue with the performance of the project or the contract, but at the same time he may be able to claim monetary compensation from B because of his failure, because of B's failure in fulfillment of the obligation of the contract. Okay, the other option is he may repudiate the contract and treat it as a discharge, where the second statement are referring to the same type of the discharge of the contract. That means A is elect or choose, or we can say select himself to discharge from further performance of the contract. Okay, once he repudiated the contract, he also entitled to claim for the damages from the other party who has breached. Okay, so this is actually number 2. If I put in the box, this is actually number 2. He can choose to repudiate, at the same time he can claim for damages, right? And then however, the other party may believe that his own action did not constitute a breach, in which case the repudiation may be a breach of the contract itself. This is another scenario where it follows that repudiation is only a good idea if the breach has been substantial. That means there are a lot of terminology, terms and conditions that are not being fulfilled by another breach party. Okay, if maybe partial or maybe small amount of the breach only, maybe the repudiation is not essential to be carried out. The usual remedy that the court awards in the case of the breach in order to pay for the damages can be seen in the monetary compensation. You can see the word compensation by way of money, because the aim of the private law is also to get the damages or compensation, right? Only in a certain circumstances the court would award a degree of specific performance. That means in the certain circumstances, if the injured party claim that he would like to get the court order to make sure that this party has carried out further performance of the contract, then the court order will be given in terms of specific performance. Okay, this is the order made against the defaulting party to carry out the contract. The second paragraph is also referring to this similar scenario. I put A and B. B is the party who is in breach. Let's say A sue B to make sure that B carry out his obligation, not to rescind the contract, but he would like to get A would like to get B to continuously carry the performance of the contract, because maybe he don't want to get another contractor. It is not easy to find another person and so on. So A will get the court order. That is known as specific performance. So the court order will be the order or instruction given by the court to give the instruction to B to make sure that he or B carry out the obligation of the contract. Okay, so what happened if the contract has broken? If we list down properly, these are the options available, these are the remedy available for the injured party, for the person who is not in breach to claim something that is due to the condition of the breach of the contract. Okay, so one of the option is specific performance, we have injunction, we have quantum merit, we have the damages in terms of monetary, or another way we have the rescission of the contract with damages. Okay, so now let's look at the first one regarding to the damages. I would like everyone to first identify the difference between damage and damages. The word damage referring to the word without S. in order for you to easily understand the term damage versus damages. The word damages, you can see the word S, you can see the letter S here. Imagine that S is monetary compensation. But the word damage is referring to damage to the property, damage to the people, okay, damage to something. That is different. So make sure you write down, number one, damages, not damage. Damages is the most popular type of remedy in the event of the breach, because either A would like to continue or either A would like to cancel. Still, both scenario, A is entitled to claim for damages. The rule relating to it has been found in the section number 74 until number 76 in the Contract Act 1950. So if you see the highlight in section number 74, this clause set out the type as well as measure the damages, as well as measurement for the damages that are able to be recovered by the injured party, which substantially reenact the common law rule as laid down in the case Hadley versus Bazendale. This is the case that highlight the possibility or highlight that the injured party is entitled to claim for damages. Okay, this is the case that always be referred as the triggered case for this particular damages issue. The second clause is clause number or section number 75 that allow the party to a contract to fix certain amount of damages to be paid in case of the breach. This is known as liquidated damages. Okay, and liquidated damages is the amount of the money that have been agreed at the time the contract is made. It is not the monetary amount of the monetary value that you only be able to claim after the breach had been carried out. Okay, I give you one example. This is also applicable in our construction industry. Okay, let's say A is a client. Okay, I put here the government, for example. Number two, the contractor, or I put MC, main contractor. At the time the government and the main contractor is making a contract, they have the term. Government already set out the term that if you fail to complete by the end or by the day of the completion date, let's say 1st of June. Okay, MC or main contractor has to pay liquidated asset damages, RM, let's say 10,000 per day. 10,000 per day. This is what happened in the construction site. Or sometimes you can see that the word liquidated asset means had been identified. Okay, had been identified. Maybe they put in percentage. If you late one day, what are the remedy? You have to pay maybe 1% from the contract amount. Okay, that is actually quite a lot because they calculate by day. If certain amount is fixed, the party that is actually in breach is responsible to pay that amount of money to the person who broken the contract. Okay, I repeat this statement. If certain amount is fixed, the party complaining of the breach is entitled to receive. The word complaining of the breach is also referring to the injured party is entitled, that means has the right to receive the amount of money in terms of the liquidated damages or certain amount that have been agreed at the time the contract is made. Okay, now you can also see this example sometime in the scholarship contract where it mentioned that the government provide a penalty of maybe a certain amount of money, in this case 70,000 in the case of the breach. Let's say during the performance of the contract, suddenly this student quit, or this student did not perform, did not get the good pointer. That are possible, where at the end they have to pay back the amount of money that is actually belong to him in terms of scholarship. Or the second one is the example that I gave you earlier. Liquidated asset A is referring to asset damages of 7,000 for each day late completion of the building. Okay, so under section 76 also allow compensation for any damage sustained by the party who has the right to rescind the contract. That means if the if the injured party rescind the contract, the other party has to pay compensation for any damage sustained by him. Okay, so now I focus on three types of the damages. We have number one, nominal damages. Number two, exemplary damages. Number three, substantial damages. So nominal damages consist of the small token award or small token of the money where the plaintiff, okay, the plaintiff always referring to the injured party, the person who bring the matter to the court, has proved a breach of the contractual right but suffered no actual loss. Okay, that means there is amount of money he would like to claim but not really considered as actual loss. Okay, number two, in terms of exemplary damages, it is the amount of money that consists of a sum that is awarded to the injured party, which is far greater than the actual loss. Maybe because of reputation, maybe because the court say that this party has to give a lesson suffered by the plaintiff, for example, in the promise of the marriage. Okay, maybe he already announced that he would like to get married with this person, and then suddenly they're broken, then they have to pay um, together with the emotion, not only by the physical, or not only by the physical loss where you already pay for the catering and so on, but because of the reputation, because of heartbroken and so on, they will consider all of this in the court. Okay, number three, in terms of the substantial damages, this is considered as monetary compensation intended to put the plaintiff in the position he would have enjoyed the contract that had been performed. This is normally a lot. Okay, by virtue of section number 74, okay, you can refer back to section number 74 earlier. Look at section number 74 in your contract act. This is regarding to the substantial reenact of the common law regarding to the case in Hartley versus Davis Bezendel. Okay, Hartley versus Bezendel. Now, if we refer to this section, the party who suffered the breach is entitled to receive from the party who has broken the contract two types of damages. Number one, they may claim for the ordinary damages. Number two, they may claim for the special damages. So what is ordinary damages? It is the amount of money or compensation for any loss or damage caused, which is normally arise in the usual course of the thing or from the breach. Okay, this is considered as normal type of the damages. They arose naturally in the case of the breach. But there are also possibility that this person or the injured party is able to claim for the special damages. This is the amount of money that can be claimed, which the party knew when the contract is made, it is likely to result from the breach. For example, let's say if there are breach of the contract, there are a lot of economic loss happen. That is one of the example. Such compensation is not to be given for any remote or indirect loss. Remote means very small amount of loss, or when we talk about special damages, it is amount of money that can be claimed because of the substantial loss. Okay, substantial loss, or maybe because of the main aim of the product, content of the contract had been broken, so it caused a lot of money that loss of money for the injured party and so on in the case of the breach. Okay, so now we look at this example of the scenario by David. You may go through this one for a while, so we look at what happened and what are the implications. Okay, David brought a refrigerator from National. This is the example. We can refer to any other brand. Within 2 days, the refrigerator breaks down and causes all the food David has kept in the refrigerator to spoil. I think if you buy the fridge, you also has the expectation that the fridge is able to work properly. Some more, this is only within 2 days. And then when you buy something, you also can see that they are warranty. It is also caused David's book, which requires to be kept at a cold temperature to be destroyed. Okay, this is also one of the important key point because David has highlighted this issue in the factual hearing. The fridge breaking down also caused David experiment which had been conducted for years, which fish in pond die because the food for the fish was in the fridge was spoiled. You can see here it is not because of the fish. Okay, the loss is because of the food that he provide for the fish, where that particular item is like chain of causation. This one because of this, because of this, because of this. So they are actually known as chain of causation. CHAIN, chain of causation. So from the above case, David sue national because you can see here David sue national not only because of the bridge has been broken, but because of this. Can you see the one that I highlighted? Okay, David experiment is gone. So this the loss is actually not only for the David's experiment, but also because of the the outcome from the experiment means the fish and the food for the fish also have been affected. So in this case, national must pay him for all the food that has spoiled because of the fridge. This is considered as natural loss. Okay, the book which Ali may claim is considered as special damage. You can see here the second statement. It also caused David book that required to be kept in the cold temperature to be destroyed. This is the book here are referring to the content of his experiment. Okay, so the book which Ali may claim is considered as special damage, where in this case, national will not have to pay compensation for it unless national know at the time the contract is made the special loss is likely to result from the breach. So in this case, they are based on the virtue of clause number 74. There are possibility that this special clause is not be able to be claimed by Ali in this case. Why? Because logically, if you buy the fridge, you cannot claim like because of this, because of this, because of this. Okay, so anyone or the representative from national also did not know about this special damage. As the fish and the whole work on the experiment, it will be considered as indirect loss and was too remote, so no compensation gained by Ali for this special damage. National only pay for the food that he has spoiled and also for the broken of the performance from the fridge itself, but not for the special damage because that is also considered as indirect loss. Because the fridge has broken, yes, naturally the food has been broken or spoiled, but because of that, because the food has broken, it caused the experiment to the fish die, and because of fish die, it caused the experiment to be fail. So you can see here it is like story by story. So that one is not granted by the court. Okay, so basically when we talk about damages, in terms of the division of money, it can be divided into two. Number one, we call this one as liquidated damages, where in construction industry we use the word LAD. Okay, you can see the word liquidated as certain damages, LAD. Okay, the damages are said to be liquidated where it had been identified earlier at the time the contract is made, at the time the contract is agreed by the other party. Okay, so when the amount of damages recoverable in the event of the specific breach, it is agreed at the date of the contract that they're supposed to pay a certain amount of money because of that particular fault. As what I told you before, they may claim in terms of per day, maybe per hour, maybe per contract value, and so on. Okay, in order for the liquidated damages to be successfully claimed and for the clause to be upheld, there are two conditions that must be met. The first one, the amount of the damages must be identified at the time the contract is made. that falls upon the party seeking the benefits of the term, as what had been stated in the contract earlier. So the keyword there is it must be roughly, approximately identified, or we can say the amount must be calculated. Okay, the second one, the damages must be sufficiently uncertain at the time the contract is made. Okay, that such clause will likely to save both parties for the future difficulty in estimating the damages. Let's say that suddenly the contractor not be able to continue with the performance of the contract. It is not easy to find what he's supposed to do, and then the cost to replace another person, and then the cost to recover the work that had been abandoned because of the act. So if the item or the amount of money did not identify earlier, it will be difficult for the injured party to consider the future estimating of the value for the damages. That is that are the reason why that are the reason that must be fulfilled in order for the injured party to claim for the liquidated ascertain damages. In the case of the construction contract, normally the court have occasionally refused to enforce LAD, choosing the following of the doctrine of the concurrent delay, when both parties have contributed to the overall delay of the project. This is what happened where maybe in that scenario, let's say A is a government, B is the contractor. If the court identify that the delay from B is actually due to the delay from A, then the court will say that this is not considered as breach of contract because this is considered as concurrent delay. Okay, what are the scenario that lead to this example of the word concurrent delay? Okay, for example, let's say B is required to construct a second floor, but at the same time, B still did not receive the construction drawing from A because A mentioned that there are amendments that need to be carried out. So while waiting for the drawing to be released, B had postponed some of the work that caused a delay, because if not, the work is not be able to be completed. Okay, so waiting for the completion of the drawing or delivery of the drawing to B will cause maybe the project to be delayed. So in that case, maybe the court did not grant the amount of money to A because both party has because both party has contributed to the breach. B did not carry out, but B did not carry out the work because the default also from A. Okay, or maybe because of the flooding and so on. They give the reason, but actually the reason also come from A. That is possible that LAD is not be granted. Now let's we go to the different in terms of the type. Number 2, we have unliquidated damages. Unliquidated damages are the amount of money that is considered as uncertain amount. Damages that are sufficiently uncertain is referring to the unliquidated damages. The amount of the money can only be identified, only be calculated by the court after the breach happened. Okay, they may be so categorized because they are not mathematically calculable, or they are subject to contingency, which made the amount of the damages uncertain. Okay, so this is something that is not being stated in the construction contract or in the terms and condition of the contract itself. When breach of the contract occurs and the legal action is undertaken, it is for the court to determine the amount of such damages. Okay, but of course the plaintiff has to prove, give evidence that because of this I suffer loss, because of this I did not get my customer, because of this I have to rent another house. Okay, so in order for the court to evaluate the amount of the damages, the plaintiff has to give, the plaintiff also has to submit the evidence so that the claim for the damages is successful in regards to all the circumstances of the case, right? Now let's go to the second one.